Hey, how are you doing? My name is Randy Hood, and I am the co-founder of a system called JuryEdge. What is JuryEdge? This is a system that I began to think about 2 years ago, 2.5 years ago, and essentially I decided that AI was giving me the ability to do things I'd never really been able to do before. And so I began to think, hey, how can I use this to help me as a lawyer? I've been doing this for, at that time, for about over 30 years. And I was like, okay, how can I make my life easier? What can I do to make me better? What can I do to have some time to spend with my wife or to do things I want to do or go see my parents? And I began to explore ways that I could use this within my particular practice. In order to understand that, I think you need to understand my practice. I come from a legacy of doing smaller rec cases and workers' compensation in the early 90s. And then I began to progress to more serious type injury cases, including nursing home negligence and medical malpractice and trucking cases, and eventually including sexual abuse cases. But the thing that I began to think about, the thing that really needed to happen was how do we begin to create a system that could be used to help everybody in any sense, in any case. It doesn't matter whether it's a $25,000 wreck case or a nine-figure trucking case. How can we have a system where we begin to incorporate the things that we've been taught through seminars, through our compatriots, through people who have been really successful, people who have written books? How do we take that and we begin to use it in a system that can help us? It could make our lives easier. It could create exposure. That could make our clients more money, and then that's a trickle down effect. We make more money, all positive. And so I began this journey about 2 years ago, in August, not even 2 years ago, August of 2024, and it was, I can always remember, it was chat four, and I was like, I've been trying it off and on a little bit. And all of a sudden I put something in there and it was like, holy crap, this is crazy, man. Look what it did. And I then began a deep dive into everything about AI. And then about November of 2024, I discovered Claude. And then there were other things coming along, but I really didn't start embracing them until probably in May, when I began to see Perplexity, Gemini, and Copilot. And I started looking at all of them. And then I kept looking for a solution. How can I take my cases and then create things that can help me, that help my clients, that can create exposure, maximize value for my client? In doing that, I think we have to look at the way we think about cases and the way that we do things. What have we always been taught? You maximize exposure by litigating a case. And so I think that this particular system is probably geared for cases that are filed. It doesn't matter if it's a $25,000 wreck case or a $100,000 slip and fall case or a nine-figure tractor trailer case. It all has the types of principles and things that are built in that will help each one of those in the same way. What are the types of cases that we're doing? And how do those things, how do we take all of that and create energy towards maximizing exposure? In order to do that, we have to look at how do we maximize exposure? What are the things that we do to maximize exposure in a case? One, we create fear. How do you create fear in a defense lawyer? How do you create fear for an adjuster? How do you create the type of energy that is required to be able to have them begin to understand, wow, if I take this case to trial, I'm going to get my butt kicked. If I get my butt kicked, then I am going to have to pay a lot of money. It's going to cost a lot of money because they're going to pay me to do this, and I'm going to have to pay for an appeal. And at the end of the day, you have to make it so that resolution of the case for a high number, higher than usual, is going to be the reasonable solution. That's what we're looking for, reasonable solution. create fear, maximize exposure, enhance resolution. Those three things together collectively are the spine and the foundation of the reason that I helped create the JuryEdge. So what does the JuryEdge do? One, a little bit of background. I've been doing medical malpractice since the mid-90s. Medical malpractice up until a year and a half ago when I began creating the system. It cost $5,000 to $10,000 in 4 to 6 months before I knew I had a case. I had to get all the medical records. And we still have to get all the medical records, but you had to get all the medical records. And then you had to go through the medical records. And then you had to have a nurse possibly, because if you get a nurse to do it, it's cheaper than going and spending $2,500 on a doctor, because a nurse will cost you maybe $500 or $750. And so if you don't have a case, well, then you don't lose as much money. But at the end of the day, it was a $5,000 investment, and it was 4 to 6 months. Today, if I have the medical records, if you take that time out, I'll know in 30 minutes or an hour. I've got a really good idea about whether I'm going to file that case or not. I then go and talk to the expert, but it isn't lost money because I know I'm probably going to file that case. So that's where it all begins, whether it's a medical malpractice, nursing home, premises liability, slip and fall, which is premises, sexual abuse, commercial vehicle case, tractor trailer, FedEx, Uber, a motor vehicle accident, sexual abuse, anything to do with a serious personal injury. And it doesn't even have to be serious. It has to be a moderate personal injury. It's something that you can use to create, not to create, but to use with the edge. So we take all the documents. The most important thing you have in regard to the JuryEdge is that we have to be able to take those documents and ingest them properly. I don't want to get too technical here because we'd be here way too long. It'd be really boring. But suffice it to say, really what we're trying to do is ingest those documents and with confidence be able to say, this is the knowledge, this is the information, these are the words that we obtained from these documents to be able to put it into our system so that it will give us output that is going to be really, really, really good. And so we start with case assessment. Case assessment is a type of thing where we put this through a very, very large granular instruction, and it then looks at everything. It looks at all the medical records. It looks at everything. If it's only medical records, that's all it looks at. But if it's depositions or medical records or complaints, documents you have received that have nothing to do with medical records, it could be FOIA documents, spoliation, things that have been provided to you, whatever it is, we feed it in. And then we get an assessment. And the assessment says, yes, you have a case, or no, you don't have a case. It tells us a lot more, but it tells us essentially whether you got a case or not. The case assessments are usually somewhere between 30 and 40 pages long. It is a very, very dense discussion of the different types of things that you have in your case. It'll talk about good facts. It'll talk about bad facts. It'll talk about how the defense is probably going to put forth things. It'll talk about standards, where the standards are, where do they come from? How do we use them? How do we deploy them? It'll talk about things that you may need to do, questions you may need to ask. And so it's a very, very, very dense summary of your case. And it ends with an expert opinion about whether there's a case, whether there's causation, and that types of damages that arose as a result of that. And that gives you a really good idea of, do I have a case or not have a case across a vast spectrum of cases. So you get that. What's the next thing you want to look at? We want to look at case framing. Before you ever draft the complaint, we want to know what the case framing is. Case framing is usually where you have a moral arc. The science would seem to indicate that jurors do not base their decision on facts. They base their decision on emotion. That's the first thing they think of. When they are there in a jury box, they think on emotion. It isn't just a jury. When I use the term jury, we're talking about the audience that you're actually talking to. The audience you're talking to for which this system was built could include the defense lawyer. It could include the adjuster, the mediator, the judge, the jury. When I use the term jury, when I'm talking about this, what I'm talking about is your audience. Your audience. That is the important person or entity that you're talking about in regard to what you're trying to communicate. You're trying to get them to understand. And so the first part of the jury edge is, after assessment comes case framing and litigation lens. If you think about this in a way, if you look at the set of you look at something on a pretty picture, think about the Mona Lisa. You look at the Mona Lisa and you look through it with clear frames and clear glasses. It's beautiful. It's iconic. But let's say you put a bunch of mud on there, and all of a sudden you're looking through muddy glasses at the Mona Lisa. Well, she don't look so good anymore. We're trying to create the same type of lens for the defendants in your case. We want him muddied up. We want to show you the things that are going to be necessary to create a very plaintiff-friendly, plaintiff-forward, plaintiff equivalent lens, so that when they're looking at this defendant, they're looking at him with a jaundiced eye. There's a lot of different things that go into how that happens, but this is about goes through 8 different things. And part of that is the moral arc. The moral arc of a story is part of the framing of the case. The moral arc is that type of thing that people understand and people agree with. People want to understand. People want to agree with certain things that we say, certain edicts. If you go and pay for a meal, you want to get what you paid for. Everybody agrees with that. That's a universal understanding. So is, if a person goes to the hospital, they should be treated before discharge. That's a moral arc. Morally, it's something that makes sense, and we accept, and we think about it from a moral position. That's the right thing to do. What's the right thing to do? And so moral arc, litigation lens, and then you begin seeing things, other things in this framing, neurolinguistics. Because what we want to do is we want to create the type of language that a juror, a defense lawyer, an adjuster, a mediator, a judge, that they're going to repeat in their head, because it's the truth. It's the core of what we're trying to propose. And so that is something that is referred to as an echo chamber. And so you want that echo chamber to exist through neurolinguistics. It's just bad. It's just bad. It's just bad. They paid for rent and got sold deception. They paid for rent, got sold deception. Those are things that people understand and people hear and people repeat. You want the thing that somebody's gonna, you think and you say it and you repeat it in your, if you've got voir dire in your state, or if you don't, like in South Carolina, we do not, but we want it in something that the judge will read to the jury. We want that type of communication, so they begin to hear this with your opening statement, with your first witness, with your cross-examination. You're building in these neurolinguistics so that the jury, when they're sitting back there and they're given their pads and their pens to be able to write with, the first thing they write down is paid for rent, got sold deception. We want to create that, and that's part of the litigation lens. That's part of the moral arc, and we begin to create that. We also have defense inoculation, because knowing our case is only half the case. That's only half the battle. We have to be able to understand and be able to agree, not disagree. That's the wrong word. We have to understand what the defense story is going to be. We can't fight against the defense story unless we know what it is. And so we have to study it, and we have to look at it. What is the defense going to say? This is a person that got in a bad traffic accident, but they had pre-existing pain. They had pre-existing back injury, but they hadn't really had anything for 4 years. They hadn't been to the doctor or anything else. And so we know they're going to say this. So what do? We begin to think about the defense framing and the defense way they're going to present it, so that we can then inoculate, and we can keep from having to eat the harm that they're trying to perpetrate on us. And so our job is to do our case, litigation lens, case framing, neurolinguistics, echo chamber, their case, know what it is. What are they going to say? How do we inoculate it? How do we spin it? How do we make it the strongest part of our case? This person had terrible back pain, but 4 years ago, they had received treatment and care, and they were okay. And for the last 4 years, they played tennis, they exercised, they played football with their child in the yard. He and his wife traveled to New York City, and they walked for miles and saw all of the sights. He lived a normal life for the last 4 years until John Smith ran a red light and he T-boned it. Now he's had his life taken because a man made a choice to go through a red light, and he's rendered him unable to do what he was able to do. We're creating story form around the defense logic, the defense story, but we're making it our own. We're not leasing out that space to the defendant. That becomes part of our ecosystem. That becomes part of our property. We own that. We take that. This is eminent domain. We take it. We don't ask for it, we take it. And when we take it and we make it our own, we've taken out one of the legs of their stool. That's litigation lens and case framing. Then the next thing in the jury edge is rules of the case. Rules of the case, most of us have heard of it, called Rules of the Road. It was a book written by Rick Friedman, and then one Rules of the Road for Medical Malpractice with Rick Friedman and Patrick Malone. It's a tome. It's something that we've all seen. It's stuff we all use. It is incredible. It's fabulous. It helps create remembrance by people. It creates memory. It creates echo chamber. And there's a specific way to form these types of rules. And you want them simple. You want them understood. You want them universally accepted. And then you need consequence. If a person decides to run a red light, someone may be injured or die. And then you give the person, and then you give the bad act, and then you give the consequence. And they need to be simple. But the jury edge does that for you. Not only does it do that for you, it then tells you why, and psychologically why it works and where it may work. It then talks about how the defense will try to turn it. And then it tells you about the kill shot, the way that you will actually take what they try to do and you make it yours again. You reclaim it and make it stronger than ever. It will also talk about, it'll give you 4 or 5. You should only use 3 or 4. The jury science would indicate that it's better to have 3 really, really, really strong things than 3 strong things and 2 moderates. Go with strength. Always go with strength. Less is more. That's science. It's jury science. We also talk about, or the jury edge also has defense rules, because once again, we have to know the defense case. This talks about the defense case, and it allows us to know what they're likely going to say. I want to know what they're going to say. By knowing what they're going to say, I can then rebut that. I can create my own framing around it. The next thing we have is something called themes and analogies. The best expert witnesses we've ever seen in anywhere, in any case, it's always somebody that seems to be an academic. The reason that they're good on the stand is because they're an academic. They teach people. When you teach people, there's a certain vernacular, there's a certain ease, there's a certain gift of being able to impart knowledge. And so we have to be teachers. Teachers. When we're teachers, the jury has a better chance of understanding. And one of the ways we do that is through theming and analogies. Theming are things that everybody agrees with. You shouldn't run a red light. That's a theme. I don't know. I'd probably have a more active voice using them, but that's a theme. And then you start you have structure to the theme. And we use that theming to teach. And the theming of the jury edge allows us to take it, and then it breaks it down once again psychologically, where you would employ it, how you employ it, and the times that you may employ it. It helps you create theming for your case, and it'll create three of them, three very, very strong themes that work together to be able to tell your story. And it works in conjunction with rules. It works in conjunction with moral arc. It works in conjunction with the litigation lens. All of these things are what is called the macro. It's the macro thing. I said that's not the facts. Facts are the micro, but the macro. And this macro is the teaching, the theme. I mean, the teaching of the case and how we relate to a jury and how we put ourselves in the same shoes that they wear. There's jury science also that, you know, when you have somebody on the jury and they're able to identify with someone, they're automatically going to put that person ahead. You're now 2-0 in the second inning instead of behind or even, simply because they identify with you. And so when you're using these types of things, you're using them to identify, and using identification and connecting with a jury, not just a jury, judge, defense lawyer, adjuster, mediator, all of these audience members. These people have to be able to identify in a way so that they're applying it to themselves. And analogies, it's another thing. Think about analogies. If you were to say a lifeguard knew a 8-year-old child was in the deep end, but then he decided to go on break knowing the child was there and the child died, what would you think? You think dereliction of duty or dumb, stupid, reckless, indifferent, terrible things, especially because he chose to go take a break knowing that there was a vulnerable person in a dangerous area. By creating that type of an analogy and then using it to show how it applied to your case, then makes somebody start thinking about it, that person or the defendant, as a lifeguard, the lifeguard that abandoned his post, the lifeguard that was reckless, the lifeguard that was indifferent. You use that to begin teaching and analogizing so that they begin to see how it fits together. It's a very strong way of teaching someone. The next thing we have is something called a defense demolisher or a defense demolition engine. This is my favorite thing. It basically takes their 5, 6, 7 strongest defenses and it demolishes them. It literally will give you what the defense lawyer's way of framing or story, and it'll give that to you, and it'll tell you why it's dangerous, and it'll tell you how to take it out. It's really, really powerful, and it's helpful, and it's easy. It basically just has it there for you. You click a link, and it does it for you. You've got to assimilate it. You've got to know it. You've got to put it into practice. But at the end of the day, it's there. Defense demolition, inoculating the defense, taking it out, burying it, making it your own. We have to know their case in order to be able to rebut their case. We also have something called the verdict mapper. Verdict mapper is something that I found, or thing I kind of thought about when I created the verdict mapper. I was thinking about, wow, most of cases, they don't come down to 50 facts or 25 facts or even 10 facts. They usually come down to 4, 5, 6, 7 facts. Really, really bad facts. The I can't get over it facts. Those facts are what drive a verdict. And Verdict Mapper helps us discover those facts, because those facts are what cause a jury to rule in our favor. And that's the micro. We talked about the macro. That's the micro. The Verdict Mapper, the facts that make a difference, the facts that are going to drive a verdict. And when I say drive a verdict, I don't mean just verdict. I mean settlement, because we're creating fear. We're maximizing exposure. We're doing this by litigating this case in a particular manner as if you had a jury consultant involved with it, because you're doing things that are usually done in really, really large cases, that are usually done even in the smaller cases at the end of a case. Well, now you're doing them at the beginning, and it starts with the complaint. It starts with the letter of representation. It starts with whatever you send first or what you file first. And it continues throughout until there is a verdict in the case. It never stops. And that's what the jury edge is all about. And so we want those facts. We want those facts that support rules, litigation lens, moral arc, themes, analogies. We've got to have the facts that prove those things. So when we're teaching, we can say, and this fact, this shows this. We're using it to teach, but we have the facts. And this, the AI and the jury edge, that's what does this. It's not me. I helped engineer it. I helped figure it out. I helped learn it. But at the end of the day, it's the AI using its magic to me, whatever it uses, to come up with these particular things. And I challenge anybody to use it because I've had numerous people use it. I've used it. My firm has used it. And numerous beta people have used it. And each one of them say the same thing. Wow, it does a really, really good job. The other thing it has, another thing it has, not the other, because there's a lot. I'm only going to get through strategy and case analysis today. But the other thing that it has in the strategy is something called an exhibit generator. We've all heard the term, a picture's worth 1,000 words. Picture's worth 1,000 words. We understand that. There's science behind it. For instance, if you have a he said, she said case and you just put up a picture of a mountain behind somebody, or you associated a picture of a mountain with somebody, the jury's going to believe him more than the other person simply because there was a picture associated with it that has nothing to do with the case. Jury science seems to indicate that pictures create credibility, create trustworthiness. That's what we need to be able to succeed. So exhibits are a huge part of the jury edge because we tell how to create the exhibit, what colors to use, when to deploy, how to use, because it's about maximizing outcome, maximizing exposure, and creating the best outcome possible. But at the end of the day, these are things that you use in a complaint, in a deposition, in a motion. I would say if you have a very important motion, like a summary judgment motion, you'd be crazy not to use pictures. A judge is he's no different than the rest of us. This is science. This is not something I'm making up. Go to AI and just ask it, do pictures create trustworthiness or credibility with someone? And look at the science that comes back. I'll do that. That's for another day because we're going to go into jury science, but jury science is more than jury science. It's about persuasion science. And persuasion science is applicable to judge, jury, defense lawyer, adjuster, mediator. Persuasion science is persuasion science. And exhibits are a huge part of that. And this does it for you. It does it for you. And we're going to talk about some other things. There's lots of other parts of this, and we'll actually go through some of this. But I wanted to at least go through and kind of give you a brief overview of what the jury edge is and what it does and what it will accomplish. And I enjoyed this. This is fun. And I look so forward to being able to speak to you. This is the first one. We're probably going to be doing this once every week or once every couple of weeks. But thank you very much and have a blessed day.